Caulkett was I found one of the more interesting decisions about what the Supreme Court didn't do, the dog that didn't bark. Professor, you want to start this one?
Well, I mean, it's essentially the fundamental question, right, in Caulkett was, should Dewsnup be expanded into an additional but obviously related area where the mortgage is completely unsecured in 506 purposes, and the Supreme Court issues this very funny opinion, yes, which basically, well, first of all, it was unanimous, but for the footnote that in and of itself makes it a little bit bizarre, in which it seems as though everybody at least is signaling that they would overturn Dewsnup, but then they proceed to apply Dewsnup into this new area, which I know Craig and I disagree on this. I mean, I kind of view this case as like
you might guess that Craig's practice is mainly secured creditor practice.
I mean, you have a case here that I'm not sure does the court any good, right, in terms of their reputation, right? You have a case here where all the justices seem to say, well, we've got it wrong in this prior case. Nonetheless, we're going to apply that case even into yet another area. I mean, it's kind of like the dentist who starts drilling on the wrong tooth and then just decides to, well, we got to finish it out, right? So we're going to keep on drilling. I mean, that's how I view this case. If you take them seriously, that they think Dewsnup was wrongly decided, why they didn't just, dismiss this appeal or something like that?
They said very clearly why they didn't do it, which I found a little bit stunning.
They didn't ask for it.
Well, they didn't ask for it, so why didn't they dismiss
the petitioner
appeal at that point or something like that? Because basically they go on to sort of expand this wrongly decided case, according to their terms, into a whole new area, just for the sake of consistency, I guess.
Well, to me, this one resolves a lot of things. In a Chapter 7, the second mortgage can't be stripped. They've been pretty clear about that.
Yeah.
I don't know that it's going to go back up. It's almost like who cares what happened in Dewsnup, that's it. In a Chapter 7, you have the cover of a statute. You've got 1322. It will be stripped. There is no circuit split in a Chapter 13, so you can strip off the second mortgage. This is another one of those that I'm like, do any of you know what a bankruptcy case is for a consumer? You represent secured lenders. Start filing your proofs of claim in 7s. We even send out notice that says, don't file a proof of claim until you're asked to. So this is one of those like, hello, earth to Supreme Court.
So let me offer a different side of this case.
Wait. Just I want to be clear here. Remember, Thomas wrote Dewsnup. Was it Thomas?
No, Justice Blackmun wrote the Dewsnup decision.
I'm sorry. But Thomas wrote this one.
Justice Thomas wrote this decision, that's right. So the Supreme Court said in Dewsnup that in the absence of a statutory provision otherwise, it's a long-standing principle of bankruptcy law that liens ride through a bankruptcy. There are provisions...
By the way, there was a statutory provision otherwise in Dewsnup, and it was very clear. The Supreme Court just said, no.
Well, I'm sorry, who drafted that provision, Rich?
We were very clear on that provision. There was no question about it.
And in fairness, if you read the language of 506A and 506D in isolation, one could read them the way that Justice Scalia would have in Dewsnup to say that under 506 you strip off liens to the extent that the value of the property is less than the amount of you strip it down to the value of the property. There were also a series of other provisions of the code that really wouldn't make sense if that were if 506 did that work. The redemption provisions.
If so, that must have been because of later amendments.
No, it was the genius of the 1978 that include the redemption provisions and the like that really wouldn't have made sense.
What's y'all's relationship here? You wrote what and you wrote what?
No, go ahead, Craig. I'm just moderating. I'm not adding content here.
You're right.
So the Supreme Court says in Dewsnup, liens ride through, and even if you're undersecured, that's not the basis for stripping off a lien. The question in Caulkett was, with all respect to Professor Lubben, not whether to extend that principle, but whether simply to apply it to the case of a wholly underwater lien where there
In a
was
7.
in a chapter 7, exactly. And no one is disputing that in chapter 13 that the provisions of section 1322 might do that work. The court says, look, you can't distinguish this case from that. There is really no plausible basis under the reasoning of Dewsnup for distinguishing this case from that. So it simply applied the decision. Indeed, the 11th Circuit decision that was reversed in Caulkett was relying itself on pre-Dewsnup precedent. And the 11th Circuit said, look, it might be that Dewsnup overtakes this, but the Supreme Court didn't deal with exactly these facts, and therefore we're going to continue to apply our old precedent until the Supreme Court says otherwise. That oral argument, the Chief Justice...
said otherwise.
Exactly. At our oral argument, the Chief Justice said, yes, you could distinguish that case on the grounds it was decided on a Tuesday, and today is a Wednesday. And one might say, why should we extend Tuesday's precedent to Wednesday? But I think the better way of thinking about it is we're just applying the precedent to these highly analogous facts. On the question of did it matter, it is true that Justice Thomas clearly believes the language of 506 did what Rich intended it to do when he wrote it. And
I'll give Ken credit for that one too. He agrees.
There was a view, right, that the language of the statute was misconstrued in Dewsnup. That's a decision that is now more than 20 years old. And what the court did essentially is left it in place, even if there were some who think it was incorrectly decided. Now, if stare decisis means anything, it has to mean that cases that you would have decided the other way, you will continue to follow. If you will follow a decision only if you agree with it, you don't need stare decisis to accomplish that outcome. And the court, in a case that was argued that same week, the Marvel case about the copyright of the sort of Spider-Man device, was similarly a case in which...
By the way, Craig, based on that statement, how do you feel about Brown against Board of Education?
I think that was correctly decided. But in statutory cases in particular, the court has been very strong about saying, look, when we're construing a statute, if we get it wrong, it is left to Congress to reverse the decision. And
the Supreme Court has about as much experience with Congress as they do with Chapter 13 cases.
How about good experience with Congress?
Yeah, despite their geographical proximity,
Yeah,
they
that's
don't
right.
seem to.
They don't
quite know
understand how it works across the street there on Capitol Hill. Okay. Caulkett, you think going to have any implications here in the Chapter 11 world, or is this strictly limited to Chapter 7?
Not at all.
Not at all.
I don't even think it's going to have I think it's going to be argued even in some Chapter 13 cases, but I think the real implication here is Chapter 7.
And the result of this is that the mortgage, the underwater mortgage, effectively gets converted from a recourse to a non-recourse obligation, right? Yeah.
correct, and the secured creditor retains the right to foreclose if it is
But no
paid.
personal right against the debtor.
Absolutely. It's the debtor receives the discharge just like the principal mortgage.
Right.